This matter, Mr. Carmichael Casali and his company, Trexico Incorporated. I'd like to reserve 5 minutes for rebuttal, please.
Okay.
My opponents have requested this oral argument today, but this is a straightforward appeal presenting a single legal question: whether the proposal for settlement served on my client, Mr. Casali, was ambiguous and unenforceable as a matter of law. The heart of this matter can be found in paragraph 3 of the proposal, which is located at R2, page 220. And if you look at that paragraph, it states that it's intended to identify the claims that the proposal is intended to resolve. It contains a single sentence with two conflicting phrases. The first phrase, quote, "Any and all claims the plaintiff, Midea Maddox, has brought against defendant Carmichael Casali as set forth in the complaint," end quote. That phrase clearly goes to just the claims in the complaint. It limits the extent of the proposal. There's a comma and the word and then the second phrase, which is inconsistent. Quote, "and any other claim or claims against said defendant that may have arisen as a result of the subject incident set forth in plaintiff's complaint," end quote. If you look to the complaint, which is at record 1, page 1, you'll see that the accident described is a bus accident. My client's truck, a passenger bus. 4 plaintiffs sued my client as a result of the subject incident described in the complaint. 2 of those plaintiffs were represented by Mr. Scott Jeeves. That's important in this case because Mr. Scott Jeeves represented Ms. Midea Maddox and is the person who signed the proposal for settlement that contains this patent ambiguity. There are a few controlling principles of law in this case. Rule 1.442 says that a proposal must state with particularity any relevant conditions. A proposal must be sufficiently clear and definite to allow the offeree to make an informed decision without needing clarification. It must be capable of execution without the need for judicial interpretation. And lastly, it must be devoid of ambiguity, patent or latent. You've heard the patent ambiguity. It's paragraph 3. It's the 2 inconsistent phrases in a single sentence. They cannot be reconciled in this case. This is similar to the Sainz v. Campos case, where one paragraph said the proposal would resolve all claims without limitation. Another paragraph said all claims raised in the suit. It limited it differently than the first paragraph. The latent ambiguity arises in 2 different ways. First of all, the scope of Mr. Scott Jeeves' representation. The Pollinger case, which we cited in our brief, establishes that the scope of representation can cause an ambiguity that will render a proposal unenforceable. Here, Mr. Jeeves signed the proposal. He represented another bus passenger at the time. He was aware of them. He was aware of the other 2 bus passengers as well. Further, the existence of other lawsuits can cause an ambiguity. The Nichols landmark case itself recognizes that fact. Nichols was a PIP case where the defendant to the PIP lawsuit, the attorney who was defending the PIP lawsuit, submitted a proposal for settlement to the plaintiff. That defense attorney was not aware that there was also a UM claim against his client at the same time pending in another proceeding. The court found that those facts render the proposal ambiguous, and that's less egregious than the issue in this case, where Mr. Jeeves was aware of at least one other claim because he represented that attorney, and possibly the other 2. I'd like to remind the court that strict construction applies here, and the proposal must be strictly construed against the offerer. He must cross his T's and dot his I's, as Justice Perriente said. That's the policy in Florida. You can't get an award of fees unless you get the proposal right. It must be unambiguous. My client isn't nitpicking the proposal or demanding the impossible. This would have been easily handled if Mr. Jeeves intended that the proposal only said claims in this complaint. All he had to do is delete the second part of paragraph 3. It has no meaning. It's not difficult. This court would have to add language to paragraph 3 or delete that phrase for him to render this proposal unambiguous. And that's something this court can't do. It cannot change the language that the offerer chose to put in his proposal.
Was there a release attached?
I'm sorry, Your Honor?
Was there a release attached to the proposal?
No court can rewrite a proposal to clarify the offerer's intent. And even if judicial interpretation was allowed in this type of proceeding, it could not eliminate that ambiguity of the 2 phrases that are inconsistent. The offerer failed his burden, and the attorney's fees award for him must be reversed.
Counsel, what's your position on the question that the judge asked you a minute ago about whether a release was attached? Does a release have to be attached to make it valid?
We did not argue that below, Your Honor. So I do not think a release needs to be attached here. We're not raising that as an argument here. The proposal itself contains the ambiguity, and the facts amplify that ambiguity that's in the proposal. Unless there are any other questions, I'll stop for you. Thank you.
Thank you.
Can you pull that back maybe just a foot? I can't see the bottom part of it.
You want closer to
No, no, back that way. Maybe, you know what, put it in the middle. It's this computer thing. Okay, thank you. Thank you.
May it please the court, good morning, your honors. My name is Michael Bray. I have David Caldevi here with me. I represent the appellee, Midea Maddox. At the outset, I would like to explain why we asked for oral argument in this case. This appeal is very important to my client. She was injured and incurred over $22,000 in medical bills. Her recovery below is about $28,000. If she has to pay her attorney's fees out of that recovery, she'll be upside down in this case. So it's very important to her, and we're here this morning so that I can answer any questions that the court might have. This appeal boils down...
Why don't you just try to explain away the two seemingly inconsistent phrases that Mr. Kukar mentioned?
Okay. Well, if I might put it on my board, I can... This is paragraph 3 right here. The phrases that he's talking about: any and all claims the plaintiff, Midea Maddox, had brought against the defendant, Carmichael, Casali, as set forth in the claim. And then the second part here, and any other claim or claims. I submit that they're not inconsistent, Your Honor, because it doesn't say or in the other claim, it says and in the other claim. As set forth in the plaintiff's complaint, which counsel mentioned, but as set forth in the plaintiff's complaint specifically limits this to the incident set forth in the plaintiff's complaint, which only describes this 3-page.
How do you say limits it to what's set forth in the complaint? It doesn't say, it doesn't repeat that language. It uses the word and.
It says, and any other claim or claims against said defendant that may have arisen as a result of such incident set forth in the plaintiff's complaint.
Well, it says claim or claims. It's almost like you could argue that they're arguing there's a third party injured.
The complaint is limited to only the accident that injured our client. It doesn't describe any other.
Yeah, but there was more than one person injured, I think, is their point.
That's not alleged in the complaint, right? The complaint is very limited.
But I don't think there's a rule of grammar that necessarily tethers those two parts of that sentence to the items set forth in the complaint. And you're saying it does, that's the only way it can be read. I don't know what grammatical rule you're employing to say that.
It says, right here. It says, as set forth in the complaint here in the first part of paragraph 3, and then in the second clause that counsel is referring to, it says set forth in the plaintiff's complaint.
And they didn't talk about anybody else being injured in that complaint.
But what it says that may have arisen as a result of the incident set forth in the complaint. I mean, that's what it says.
That's the only incident described in the
So, yeah, but in that incident, there was more than one person injured.
Well, the complaint is very limited.
But complaint is just where this description of the incident is. It's in the complaint.
That's correct, Your Honor. I guess I would also say that my client had no standing or authority to settle anyone's complaints. But
I mean, it's not really sort of the heart of your argument. Is it substantively, you know, the interpreting it as ambiguous makes no sense?
That's absolutely right, Your Honor. I think that it is a substantively unreasonable interpretation.
Because the alternate interpretation that they're proposing, just it legally.
It can't happen.
It's a legal impossibility, isn't that your
That's
argument?
exactly right, Your Honor. It can't happen. My client, there's no authority, no support in the law for the idea that my client would be able to walk around and offer to dismiss other people's claims. She's the only plaintiff in this case, and she just can't dismiss anyone else's case.
If I rephrased and if I'm rephrasing it wrong, I want to make sure I understand your argument. you're saying, well, yeah, it might have those two meanings, but one of those two meanings is a legal impossibility.
That's right, Your Honor.
It's not a reasonable alternative.
I would agree with that, Your Honor. I don't concede that it's ambiguous in the first place, but I do think that if it can be read to have two meanings, then that second meaning is completely unreasonable and an impossibility. And so I would say that the court would be nitpicking this proposal to create an ambiguity that really is not there and can't happen. Okay. So like I said, I would direct the court's attention to the case of Carey, all transport against Newby, which is a case out of this court, in which the court said parties should not nitpick the validity of a proposal for settlement to create an ambiguity unless it could reasonably affect the offeree's decision. And like we just discussed, this could not possibly reasonably affect the offeree's decision. I would also add that there's no evidence in the record that the appellant ever brought this up until after the trial occurred.
Well, isn't that when you normally argue the offer of settlement?
Well, if it was truly unclear...
You're not arguing that they have some obligation to ask you to clarify.
I'm not arguing there's an obligation. I'm saying that there's no evidence in the record that they sought any clarification or that there was any indication that it wasn't understood. That's all I was saying.
But isn't it okay for them to sit back and say, well, it's ambiguous, it's not going to be enforceable, and we're just going to let it ride? I mean, there's nothing that prohibits them from doing that, right?
That's
it's
correct,
a matter of
Your Honor.
strategy?
That is correct. That's correct.
There should be, but there isn't.
I'm sorry, Your Honor?
There should be a provision, as the judge has suggested, where you have a response of some kind if you feel that something's ambiguous, so you could ask them to clarify it, but the statute doesn't have anything like that in it.
I agree, Your Honor, I agree. If I could just briefly distinguish the signs case the counsel brought up. That's distinguishable from this case on two grounds, as we've said in our answer brief. The signs case, number one, there was a bad faith claim that was floating out there in that case. And so it was not clear which claim the proposal was purporting to dismiss. And the second thing is what we already talked about. There were conflicting provisions in the signs case, and they're not conflicting provisions here. So are there any other questions? If there's nothing else, in closing, I'd like to go back to where I started. I mentioned at the beginning that this appeal is important to my client. I'd like to explain briefly why it should be important to the court. If proposals for settlement are not enforced, people like Midea Maddox are not going to be able to find counsel in cases like this where there's $20,000 or $30,000 worth of injuries, because the amount of controversy is more than the attorney. It's less than the attorney's fees are going to be. So the offer of judgment statute is really the only thing that makes it feasible for firms to take this kind of case.
Which makes it really important to be careful when you're preparing the offer of judgment.
Your Honor, since we have time, may I be quickly heard on Your Honor's question about the motion? I mean, whether or not opposing counsel had a duty to request clarification. Of course, they have a duty to do that, but people do file motions to strike offers of judgment that are vague or ambiguous or have problems, because it does put, it's an important decision to make at that point in the case. If this is an offer of judgment that they were seriously considering to take, and they had a question that this was ambiguous, to make a tactical decision to sit on their hands and not request clarification or move to strike it, I think that goes to show that it did not affect their ability to make a decision about this offer of judgment as to whether, the question is whether there's an ambiguity and it reasonably affects your ability to make that decision.
Part of your argument is whether it could reasonably have impacted their
Exactly.
decision-making process, right?
And I think that goes, the fact that there's no evidence that they requested clarification or moved to strike this offer of judgment is clear evidence that it didn't affect their ability to accept or reject this. There's only one person making this offer, and that is the plaintiff. It's repeated 6 times in that offer of judgment. Our client had no authority to settle any other claims. And Judge Volanti, your question about the grammar is clear. It says any and all claims in the complaint and any and all claims concerning the incident described in the complaint. There's only one incident described in the complaint. Yes, it is a bus. Yes, it was a bus. Are we offering to settle the impact to the bus and everybody on the bus? Of course not. That would be absurd. That's preposterous. It's an impossibility. So for these reasons and the reasons stated by my co-counsel, we request that you affirm. Thank you.
Thank you.
May it please the court. Your Honors, first I'd like to clarify that the proposal does not say any and all claims described in the complaint. It says any and all claims that could have arisen as a result of the incident described in the complaint, as Judge Kelly pointed out. And that can reasonably be understood to mean any and all claims outside of the complaint as well as in the complaint. But that actually isn't what my opposing counsel has argued in their answer brief. If you look to their answer brief, on page 16, they argue that the proposal is clearly limited to the specific claims set forth in the complaint. But today you've heard that the word "and" has to be operative, and the second part of that phrase has to be read in inclusion with the first. The second part of the phrase clearly means things outside the complaint. It can't be read the way my opposing counsel wants to read it. They keep providing inconsistent positions because there's no way to cure the inconsistency. I'd like to respond to a couple of the questions from the panel. Let's see. Opposing counsel, in response to one of your questions, I think it was Judge Kelly, said that there was that his client did not have any authority to present a proposal for another person. I would like to point out that his client's attorney is the person who sent us the proposal. And his client's attorney.
But I think really, you know, to be fair, what their argument is your interpretation that it is really a legal impossibility. So why don't you address that? I mean, how could this one party offer to settle other people's claims that aren't even part of the lawsuit? They're saying that's a legal impossibility.
Yes,
so your suggested alternate interpretation is not reasonable.
Yes, Judge Kelly. Again, I would point out that his counsel is the person who served the proposal, and it's possible. There's nothing in Rule 1.442, or at least the version that applies to this case, which I would note is not the version that's cited in their brief. The version that applies to this case does not say anything that would potentially limit how a proposal is written in this case.
Well, I mean, I understand what what you're getting at in terms of it was served by the attorney,
yes,
who's representing both these parties, but ultimately the person that's entering into this is not the attorney, it's the client. So
yes.
How could the plaintiff release the claims of the other parties that were injured that aren't really part of that lawsuit?
Well, I would say that this happens in cases all the time where there's vicarious liability for defendants, where one party incorporates another party into a dismissal, where that second party might not be a part of that lawsuit at the time.
Okay.
So it can be done. And I haven't seen a case where it's plaintiffs.
That vicarious liability was not an issue in this case.
No, it wasn't. And I haven't seen a case where it's two plaintiffs, such as this scenario. But I haven't seen a case that says that can't be done either. And therefore, it could be.
Let me just ask it differently. So,
yes.
Are you saying that it would have been legally possible for Ms. Maddox to release the claims of any of the other individuals who were injured in this bus accident?
Arguably, I believe the wording of this proposal could potentially release other claims. And if we had accepted that proposal, that is probably the battle that would go on afterwards. We would say that this proposal satisfied not only Midea Maddox's claims, but at least Jory Church, the other party.
Let me just clarify your statement. You're saying arguably this proposal could be interpreted to release other claims?
Yes.
Okay, and is that reasonable if you can't give us an example how? I mean, saying it's arguable, that's like saying a comet could come down and hit us.
That's a legal impossibility. Like, even if you can read it that way, it's a legal impossibility for her to do that.
I don't think it necessarily is a legal impossibility, but if we're getting into this interpretation, I think we're going far beyond the interpretation necessary for determining whether a proposal is ambiguous or not. If it could be read two ways, that's the only requirement that renders
Well,
it ambiguous.
yeah, but it has to be, it has to be two reasonable interpretations.
Well, there's other ambiguities as well that my opposing counsel has raised. My opposing counsel said claims limited in the complaint and has included the other part, and any other claims. My opposing counsel in their brief at page, how did we get their page? At page 16, suggests that means other claims that Midea Maddox might raise that are outside of this complaint. So there are several ways that this proposal is potentially ambiguous. I've only raised one of them, but my opposing counsel has raised another by raising inconsistent arguments on pages 16 and 17 of their answer brief. I'd just like to close, Your Honors. We agree that this court should read the proposal as a whole, read paragraph 3, look at the comma and the word and afterwards, and determine whether that creates an ambiguity in the proposal. The only way to reconcile the phrases is to rewrite the proposal to make it clear that the proposal either applies only to Midea Maddox or potentially applies to other people, whichever the plaintiff would be seeking to do. And that's why this court cannot rewrite the proposal for them. The burden was on the offer to draft that proposal clearly. Otherwise, under the plain law of Florida and the policy of Florida, they cannot get an award of fees in derogation of common law, which is that each party pays their own fees. Unless there are any other questions. Thank you, Your Honors.
Thank you. All right, thank you both. We're going to adjourn for about 10 minutes, and then we will begin our second half of today's session. Thank you.